Okay, well, good afternoon, everybody. Thank you for joining us once again for part 2 of this presentation, which is Mastering Licensing Investigations. This second part, after we tried to demystify the whole process with the first part, it now deals with how do you actually respond to a licensing board investigation or a patient complaint? What do you do when you get that letter or when you get something from the board that's going to obviously rattle your cage a little bit? It's perfectly fine and normal for that to happen. It's unfortunately a cost of doing business for some areas of specialty more than others, but it's not something where you should panic or feel overwhelmed. What we're trying to do here is explain to you some of the basics, some of the things that you should be wary of, things to avoid, things to do. As always, we can't give you legal advice. That's our disclaimer right now, but we are going to try to give you as much common sense guidance, so as to not call it legal advice, in the event that you find yourself traversing these waters alone. Although we do suggest that, as we discussed earlier in our prior presentation, that you do have healthcare counsel available. Frier Levitt is a healthcare boutique firm. We've been around for over 25 years now, almost 25 years now. And we are national in scope. Our main office is in Pine Brook, New Jersey, although we also have offices in New York, and we work nationwide. Alan, my co-presenter, and we actually have represented practices all over the country: California, Florida, Michigan. So we have seen what we're talking to you about today. And when we give you our legal advice, if you are one of our clients, it's really based on a collaborative effort with other attorneys sometimes. And it's also based on our accumulation of experience, not only in New Jersey, but in multiple jurisdictions. And what we're going to talk to you about today, having handled board matters in other states, I could tell you is universal, regardless of what state or regardless of what licensing board you're dealing with. Again, for those of you who did not join us at part 1, my name is Guillermo and Alan. I'm a partner here at Frier Levitt's Healthcare Litigation Department, and I co-chair the Insurance Defense Department, where my co-presenter, Alan Blankstein, works. We represent healthcare professionals in all types of administrative, civil, and sometimes criminal healthcare matters, although we do defer criminal litigation and things of that nature to our colleagues who are former AUSAs and prosecutors. Most of our work with Alan is before the Board of Medical Examiners, although we have represented licensees in many boards in New Jersey and out of state as well. And a lot of our work is also based on audit defense, overpayment demands, credentialing issues, any type of dispute that you have with an insurance company. In addition to doing all of the work that I just mentioned, Alan, our co-presenter, Alan Blankstein, he actually worked at the Deputy Attorney General's office, where he actually prosecuted cases for them. He was on the prosecuting side, and he worked with the Board of Medical Examiners closely on disciplinary actions against physicians. So some of the insight you'll hear today from Alan is from what he experienced when he was on the other side, things that he noticed when he saw a doctor come in, for instance, unrepresented. What were some of those dangers? So jumping right into it, how do you triage a letter that you get from the Board of Medical Examiners? So the first thing we want you to do is obviously read the letter from the top to the bottom. The letter is going to tell you a lot of things that you have to extract from it. You need to understand, does the letter have an enclosure? Maybe that's going to be at the footer of the last page. If it says that it has an enclosure, but you only receive the letter and not the enclosure, that's pretty important, because the enclosure might be the actual allegations from a patient complaint, might be a subpoena that they're sending you, might be a document request. It could be a number of things. It could be a form that they want you to fill out, that if you don't fill out on a timely basis, it might lead to some discipline. Always look at the letter from the very first line to the very last line, so you know exactly what you should be looking out for. Extract key information from the letter. The Board of Medical Examiners, they use a lot of form letters. and they will all say the same few things. One, they're going to tell you what the reason is that they're reaching out to you, who they're reaching out to you on behalf of. It might be a particular subcommittee of the board, like a preliminary evaluation committee hearing that you're being scheduled to go before. They'll tell you what the key dates are. And the key dates aren't just when you have to give a response by, but it's also when you have to alert the board of your unavailability to appear. You might have a pre-planned vacation, you might have an engagement that you can't move. The board is going to be very reasonable with you, and they will allow for a reasonable extension of time. If let's say they scheduled you for this coming Thursday, but that's your surgery day, and you have surgery scheduled for that day, they'll move that date. If you don't tell them about it and it's the day before and you decide, oh, well, I can't show up, or you just don't show up without letting them know, they will take that personally. They will discipline you. If you don't request an adjournment in a timely fashion, that's going to work against you. So again, our position is you have to look at every single date on a letter. It's going to tell you a lot of things, including when you can request an adjournment, something very simple. Another key piece of information is, the person doing response is required. Are you sending the response to a deputy attorney general, to the executive director? That's important to understand, because a deputy attorney general isn't assigned until there's an issue for them to be involved with, meaning it's a prosecutorial deputy attorney general who needs a response for you before they can give their advice to the board as to how the board should proceed. If your response needs to be sent in to a deputy attorney general, DAG, you have to get counsel involved, because this could be disciplinary action, and disciplinary action 100% of the time is public in the state of New Jersey. So you absolutely cannot, play it by ear. You have to get an attorney involved if a deputy attorney general sends you a letter, or if a response needs to be sent to a deputy attorney general. Again, does a letter mention any specific patients, treatments, date of services? This should help you clue you in as to what they're looking for. The board won't tell you outright what they're investigating many times, but they will give you enough information, enough context clues, that if they give you, for instance, 10 patients, and every one of those 10 patients got, a vein ablation procedure, that they're looking at that. Or if you're looking at 10 patients and they're all out of network, and maybe you've had some issues with billing them. Maybe they had, even a couple of them maybe complained to you about your excessive charges. Again, that'll help you clue you in as to what they're looking for. Determine whether you have been previously contacted by the board. Sometimes the letters will say, we attempted to reach out to you on X date. We've gotten a response. This is our second follow-up. Anytime you see a letter from the board that says this is our second follow-up, third follow-up, now you have to treat it with urgency, because the board on occasions will be understanding enough that maybe something got lost in the mail, maybe it got to your office, but your staff didn't turn it over to you. But once that happens, they always follow up with a much more stern follow-up. Sometimes they'll send a subpoena instead of a written letter request. So once you find out that this is the second time the board is reaching out to you, you have a duty to cooperate with them under New Jersey board regulations. You have to make it a priority. When you see from the letter what they're asking for, make sure you gather all the information that's relevant to maybe the patient that they're requesting, the treatment reference in the complaint. Try to gather all of that information as quickly as possible. And then when you meet with your attorney and you show your attorney what documentation you put together, your attorney may suggest some additional records, maybe an attestation from you, maybe a certification or an affidavit to support some facts. It's important that you get those records together as soon as possible. And of course, we've discussed this. You want to involve legal counsel. So I'll turn it over to Alan because he was obviously at the board himself, so he can explain to you a little bit of how the board is going to contact you.
All right. Hello, everybody. Thank you for coming to our webinar. So how will the board contact you? The typical way they contact you, and probably 95% of all cases, is to mail you a letter to your business address on file. It can be a variety of different letters. Sometimes they will mail you a letter that includes a patient complaint. Sometimes they will mail you a letter that's a demand to appear before one of their various panels. Sometimes they'll send you a letter requesting additional information or something like that. But typically, when the board wants to reach out to you, like any other government agency, they will mail you a letter to your address. The letter will alert you to a due date for a written response, or if there's a hearing date, it will sometimes, but not always, alert you to the allegations being investigated. And we'll get a little more into this later on, but depending on the type of letter, they may not tell you anything other than the fact that you need to appear before the board on a certain date, that you need to send in a certain amount of records. But if it's a patient complaint, they will almost always include the allegations so that you can respond to them. If there is a deputy attorney general assigned to the case, it will tell you that. Otherwise, it may just tell you to respond to their generic address, and some of them will also inform you as to any procedural issues or rights you have, and the letters will also always remind you of the fact that you have a duty to cooperate with the board. The reason I say that this is not the way that they will always contact you is that they have other means of getting in touch with you. The other one that they typically will follow is that they will send an investigator out to your office personally to serve you with a subpoena. The subpoena will typically be for patient records, or have an investigator come out and serve you with a demand to inspect your office. That's another way they'll contact you. But typically, when the board wants to reach you, they won't call you. They will not email you. At least when it comes to discipline, they will send you a formal letter. And it's just important to keep this in mind, because we have had instances in the past where some of our clients have called us because they received a call from the quote unquote board saying they had to follow all of these various steps in order to avoid discipline. And they'll usually be pretty vague about what board or government agency they're calling from. And it turns out it's just one of these scams where they're trying to get the person to buy a bunch of gift cards to send them to avoid any alleged discipline. So it's important to note that when the board's going to contact you, they will send you a letter. They will send somebody personally with something signed by somebody from the Attorney General's office or the board. They will not call you. They will not email you. They won't do anything like that. So when do you get legal counsel involved? Really, you should get legal counsel involved the second that the board reaches out to you when there's discipline as a potential conclusion to the matter. These matters can become very complicated very quickly, and people who are unrepresented often aren't cognizant of some of the pitfalls that they can fall into when even responding to something as simple as a patient complaint, even when the patient complaint is completely baseless. The reason that it's important to get legal counsel involved at that initial step is really twofold. The first reason is so that you can ensure that you are responding to each and every allegation that's listed in the patient complaint in a satisfactory fashion to stem any potential further discipline that may come down the line. If you don't get rid of the patient complaint right away, while the ultimate resolution may be the same, the board may determine there's no conduct that is not worthy of discipline. It can lead to significant time and expense appearing for a board hearing, a panel investigation, or a subpoena production, or something like that was completely unnecessary had you had competent legal counsel involved right at the start. If you are called to a preliminary evaluation committee hearing, which sometimes is the first step the board takes in more significant allegations that they receive, or a medical practitioner review committee, which would be the first step in the case of something like a medical malpractice case or some kind of discipline within a hospital, you should be accompanied by an attorney to that hearing, and you should work with an attorney to prepare you for the actual testimony prior to appearing. This is very important because we have gotten involved in many cases where the physician appeared before one of these committees on their own, and while they were able to answer all of the questions in a truthful manner, they were not prepared for the types of questions that they may be asked, and were unfortunately cornered into some areas that they really did not need to be discussing with the board in the way that they did, and that led to some significant problems further on down in the investigation. And then finally, if you receive a letter from the board advising you to show up for an order to show cause hearing, you will need counsel to appear with you. While it's not required to appear before the board that you have counsel with you, these order to show cause hearings are no different than any other legal hearing that somebody may appear for, such as just a civil motion practice, a criminal arraignment, something like that, where you actually will have to get up before the board and defend whatever conduct is being alleged against you. And it will always be to your best interest to have competent legal counsel appear from you to advocate on your behalf in a forum such as that, rather than to appear on your own.
Yeah, and to Alan's point, one of the reasons why sometimes you want legal counsel involved is because there are procedural reasons to object to some of these hearings that, quite frankly, unless you're an attorney and you practice in this area, you just wouldn't know about them. For instance, we've had a couple of cases where after fighting with the board and their attorneys for years, they decided to have an order to show cause to suspend the license of one of our clients. Well, we showed up and we made it pretty obvious that if the board really had a problem with the way this practitioner was practicing, they should have taken this action to suspend the license and privileges of this physician years ago, not because they couldn't get the settlement that they wanted, and that was we won that pretty handedly. So that's one thing to be very keenly aware of. There are procedural reasons also how you can fight things. And when the board comes to you asking you to appear before a hearing, to surrender your license, anytime they want you to sign away any rights, that is literally the time when you have the most leverage you will ever have against the board. Once you sign something away, good luck getting them to pick up the phone. But once you have what they want, they will listen to you. They will talk to you. They will talk to your attorneys. They will negotiate. Once they have what they wanted, then it's much harder to get them to come to the table. So one thing that we always get asked is, what are my rights? Well, many times you can obtain an extension to answer, like we discussed before, maybe an adjournment of the hearing date. Sometimes the exception is the order to show cause. A timely filed order to show cause, not something after multiple years like we were just discussing, that is actually difficult sometimes to adjourn, because the board is literally taking the position that to allow you to continue to practice would be dangerous to the public, and they have a duty to safeguard the public. So it's a little bit more difficult to get those types of adjournments. And when you do, it's for maybe a week or a few days. It's not for months down the line. Understanding that you have the right to counsel. It's not an informal hearing. It's not something that should be taken lightly. One of our colleagues, my partner, Lucas Morgan, gave a wonderful 3-part presentation similar to ours, but on the pharmacy board matters. And one of the things that he and I were discussing recently is how sometimes the boards are intentionally deceptive. There are some states that I'm not going to name right now, but there are some states that name their hearings instead of a preliminary evaluation committee hearing an informal hearing or informal conference, but they're anything but informal. And you do need an attorney, and they have the same power after having one of those quote unquote informal conferences to suspend your license, to take away your right to your privileges. So it's very important that when you hear from the board, when you speak to investigators, you understand that the worst case scenario is they take your license. So that's why it's important to have legal counsel involved. You have a right to defend yourself by providing medical records, billing records, a certification or an affidavit that your attorney can help you provide, any documentation, any proof that will defend you, calling in patients, witnesses. You have the right to defend yourself and use any tools that you want. You do also have the right to speak with the investigator or deputy attorney general prior to a hearing. That's something that we never suggest that you do yourself. Your attorney should do that. We frequently do that, and part of that is to set some ground rules for the hearing, which is very important, because we don't want you walking in and expecting, a million questions. If we can agree to the scope of questions, the main theme that's going to be addressed at the hearing, that makes things go a lot simpler, and it's easier for us to prepare you. So some of the do's and don'ts, and obviously Alan's going to jump in on this one with me, because he helped me prepare this part, and he's seen a lot of the don'ts from his time at the board prosecuting, which at that time probably wasn't a don't for him. It was a thank goodness, made his job easier. But the one thing that we say, and it's not to hawk for business or anything, it's hire competent legal counsel. That means someone who understands what a board hearing entails. At part 3 of our 3-part series, the next one, we're actually going to go into and take a deeper dive as to what a hearing is like, the type of questions that you'd expect. And this is precisely why you hire healthcare counsel, because you've done it enough, you know the type of questions to anticipate. Back when I used to do a lot of litigation, back when I used to do a lot of personal injury, mass tort, I knew what those questions were going to be like for my clients before they even stepped foot into a deposition or into a trial. I knew exactly the type of questions that were going to be asked, because I had done over 1,000 motor vehicle accident depositions. I knew the type of questions to ask. Same here in this arena. We know the type of questions that doctors ask doctors, that deputy attorney generals ask doctors. So it's very important to have somebody on board.
And even more so than just the preparation part, which is also very important. When I was a deputy attorney general, we had a doctor show up to a PEC hearing completely on his own. It was alleged that he had expired medications in his office, that his office was a complete mess, that he was mixing infusions on a vanity armoire. The whole case was a big mess. But he appeared without counsel. He was completely unprepared. He showed a significant disdain for the practice itself, and for the panel itself, and for the fact that they were investigating him at all. He did not perform well in the board hearing, and at the end of the PEC, I asked him, if I send investigators out to your office in 2 weeks, will the changes you claim will be made? Will they be made? And he said, yes, they will. And we sent investigators back out in 2 weeks, and he hadn't made any changes. And obviously that has nothing to do with counsel, but counsel would have advised him to make the changes he put on the record, saying, I'll clean up the expired medications. I will stop. I'll get a real hood to do my infusion mixing on. I will all these different compliance things. He had a broken thermometer in the refrigerator he was storing medications. An attorney would have advised him to make these changes, could have negotiated with the board to have the investigators come back at a more reasonable time. And lo and behold, when he walked out of the PEC hearing, the members on the panel said, well, we need to take his license from him right now, because he showed up completely unprepared, completely unable to answer the questions. I'm not sure that they would have had the same opinion if he had shown up and been able to answer the questions and shown the deference he would have had he been prepped by competent legal counsel. So it really does make a difference in these types of cases.
No, that's completely on point. And I've had situations where I've had to counsel my clients to make sure not to make any promises to the board that they cannot 100% back up. There are easy ways, and we'll get into this in more detail at the next session, but there are ways where you can answer questions. And again, as attorneys, we don't tell you what to say, but when we hear when we prep you the way you want to explain something, sometimes we'll have feedback as to how we hear it. So sometimes you might think you're saying one thing, but we're hearing something completely different. And the devil's in the detail, because you're going to have an attorney listening to you, the deputy attorney general, plus multiple physicians. So part of our work, and where we really earn our money, is what I tell all our clients, is in the prep work and making sure that you are early out to them. No areas to stay away from. It's pretty straightforward prep work in that sense, but it takes a long time and a deep understanding of what you do and what the board is investigating. So a lot of this do's and don'ts here, this list we've gone over before in our prior presentation. We'll touch upon them in the next one as well, because they're pretty universal in the sense that, for instance, you want to gather all facts, whether you're going on a hearing or whether you're going to be responding in writing. The biggest takeaway from a patient complaint that I can give you is that you control the narrative when you're responding. If you go to a hearing, they can ask many follow-up questions, and they have wide berth. They can go into any area. They can start talking to you about your malpractice coverage, what your plans are after retirement. If you're close to retirement age, are you planning on retiring? Why do you even want your license still if you're going to retire in 6 months? So there's a lot that goes into prepping for a hearing, which we'll go into in the next part of this presentation. But if you can take one thing away from responding to a patient complaint, is be as thorough as possible, explain things well, and avoid treating it as if this isn't a big deal. You have to respond to all of the allegations. Don't be dismissive. Don't be combative. You'll see that it's going to work out much better for you if you address all the complaints, put all of your proofs before the board in your response, and that's going to give you the best footing going forward.
So responding to the board in a proper manner. I think importantly, everyone here should note that licensing boards can be arbitrary and capricious at times. Really, at all times, they have significantly more power than you think that they do over your ability to practice medicine. So it's important to never give them a reason to take any action or to want to take any action against you. The example I gave about the unrepresented physician in the last slide is a good example of that. But also, even when responding to a patient complaint, don't give them any reason to remember you for any bad reason. Make them come away thinking, all right, this guy or girl treated the patient appropriately at all times. They seem like a competent doctor. That's the impression you always want to give them, so that they don't act in an arbitrary manner. It goes to the second point: respond to a complaint without emotions, preferably through counsel. This is obviously easier if it's through counsel, because your counsel isn't personally engaged in the actual complaint. They're not emotionally engaged with receiving a patient complaint and going through all of the processes that come along with that. So if you can have counsel respond to the complaint for you and to communicate the factual component of it in a neutral, unbiased, clinical fashion, that's really the best way to respond to a board complaint. Respond to any request for records or narrative response in a timely manner. The board, unlike many other government agencies and even civil litigants, They are willing to work with you regarding deadlines and due dates, but you have to be willing to work with them. You have to ask for extensions with adequate amounts of time and adequate justification. And you have to, at some point, be willing to turn over whatever it is that they're asking for. So you want to make sure that when you do get a request, you're either responding within the due date that they provide or immediately asking for a reasonable extension to that due date, and then responding by the day in which the extension was provided for. Address all patient complaints, no matter how ludicrous. Yeah, it does sound crazy when you receive some of these patient complaints and see the things that the patients are alleging. They're clearly have nothing to do with patient care. They may be clearly made up. They may be clearly just crazy statements that the person is making, have nothing to do with anything the board regulates. However, you want to make sure that even if that's the case, you're responding to those allegations by saying that they're flatly not true, that they have no basis in what happened. They have nothing to do with the practice of medicine, whatever it may be, but you want to make sure that you're responding, not giving the board a reason to continue its investigation by calling you in to address some of these more ludicrous complaints, or even if it's something that seemingly has merit based on how the patient addresses it. If you forget to respond to it in your response to a patient complaint, the board will often call you into a PEC to discuss those allegations, and a PEC can lead down many different avenues you don't want to go down. And then finally, remain above the fray. It's very important when responding to a patient complaint to not attack the patient. Some people get very upset with the patient, get very upset with the allegations, and really want to show that the patient themselves is an unreliable narrator, that they're not somebody to be trusted. And there's many different ways to do this. And in a situation where you're responding to a patient complaint as a professional, often the best way to do it is not to personally attack the patient, but rather to show competing facts that infer that the patient is unreliable. And it's oftentimes, when you're personally involved, very hard to do this, which is, again, why we always recommend that physicians seek legal counsel when responding to a patient complaint.
Yeah, to that point, one of the things that we do is, the last thing that you ever want to do is call a patient a liar, but many times we'll find ways to bolster our client and their character as a way of, separating them from the complainant. So you don't necessarily need to go hard at the complainant to say, hey, they're crazy and look at this. You just say, you just speak highly of your client. We like to talk about, if you have any board certifications, years of experience, note how you remained a consummate professional throughout the entirety of the, maybe screaming match or the yelling that happened in the office or against the office staff. We see that a lot. Those are things where we can advocate on your behalf. And it's never in a attacking or negative type of way towards the patient, because we also want to remain above the fray as much as we can, even though we're still zealously advocating for you.
Yeah, and it's also important to note just that, if a patient complaint seems crazy to you, it's likely it sounds crazy to everybody. So you don't need to necessarily point that out in black and white language. The people who read these patient complaints are humans too, and typically are also physicians, and they're familiar with the types of issues that physicians deal with on a day-to-day basis.
And this slide, avoid common mistakes, I'm going to spend 2 seconds on it because we've already discussed this. Is just again, we don't mean to hammer the same points at you again and again, but this is exactly what happens if you go before a board hearing, where they will ask you the same type of questions in different ways. So we're presenting you some of the information in slightly different ways, but again, it's because I want to make sure that you really understand some of the common mistakes that we see a lot, many times when we are called to represent a client after the fact. So it's, again, avoid blaming the patient. We just went into a lot of detail about that. This is another one that's along the same lines. Avoid blaming your staff or other providers at the practice. Sometimes, listen, sometimes it is somebody else's fault. Sometimes somebody forgot to call the patient and give them their test results. That doesn't mean it's an opportunity for you to write a 3-page letter stating how incompetent the staff is and how, you need help and you rely on them and they should be able to make a simple phone call to give them, this information. That's the last thing we want you to do and we would ever do. But there are ways to say, listen, this was something that was completely atypical for us. It's the exception to the rule. It's not how we typically operate. We have retrained our staff. You want to allay their fears that this is going to happen again. You want to make sure that after someone reads this, they don't think, wow, like this poor doctor, look what they have to deal with. Look how bad their staff is. They'll never think that. They'll think, you are the captain of the ship. And they have used that phrase with us and on more than one occasion, and more than just one board has said that to us. Your client's the captain of the ship. If their staff is bad, it's because they weren't trained properly. If their staff is not doing something correctly, the buck stops there. If they didn't bill something correctly or they overbilled something, that's on them. They're signing off on these bills. So one big common mistake is blaming others. Try to avoid that, and there's a way that you can clear things up in a response without actually being accusatory. We talked about before about you don't want to miss deadlines. And then one of the reasons that a lot of doctors mistakenly go to the board unrepresented or respond without, conferring with counsel is because they think they're talking colleague to colleague. And we've gotten that many times before. This is why we harp on this. Don't underestimate the fact that the licensing board, regardless of what your license is, regardless of what state you're in, don't underestimate that they have to ensure the safety and welfare of the public. Okay, so when you go for a hearing, when you respond to a written complaint, you have to keep in mind that the person reading this is reading it under the scope, under the prism that, how is the public being protected? Is this provider continuing to practice unabated with an unrestricted license a potential harm to him or herself, potential risk to somebody in the public? That's the prism that they look at this through. So don't think of this as an informal proceeding. And then lastly, to reiterate what I said earlier, never accept consent orders or propose discipline without conferring with counsel for 2 reasons. One, all discipline is public. It goes in the National Practitioner Data Bank. And that means that payers, that means that hospitals, nursing homes, anywhere where you have credentials, that means that other licensing authorities, so if you have licenses in 3 or 4 states, those other states will now investigate you as well. It is across the board. Never accept any public discipline or in terms of consent order because they're all public without conferring with counsel first. The second part of it is when you get approached with a consent order or any request to sign something, give up a right, whatever it may be, that's when you have the most leverage. And you'll never have that much more leverage with the board ever again. So use it to your advantage. Try to get them to the table to be reasonable with you or to allow you the time to explain any misconceptions that they may have.
So we talked about how 95% of the time the board will contact you by sending a letter to your business office that they have on file. The other 5%, or maybe you want to call it 4% of the time, they will have Enforcement Bureau investigators come out to your office. These investigations are either being spearheaded by the Enforcement Bureau, which is the investigative arm of the Consumer Affairs Department, or they are coming at the direction of a deputy attorney general. So when an investigator comes to your office, it's most important to simply confirm that they are who they say they are, because you don't want somebody coming to your office claiming they're there as an agent of the state and you letting them in and look around if you don't know who they are. They will come in with badges, and you can confirm who they are by looking at the badge. If you If you really need to, you can always take down a badge number, call Consumer Affairs, and have them confirm. This is the best way to do this, though, would be to, if you're represented by counsel, to have your attorneys confer with Consumer Affairs. Determine whether or not the investigator is with other law enforcement. They sometimes will show up by themselves, depending on what they're investigating, but sometimes they'll show up with either local or state police. Sometimes they'll show up with a federal official, such as typically a DEA agent. If they show up by themselves, as we discussed in the previous hearing, they'll need to have something signed by a deputy attorney general requiring that you either hand over a production of records, allow them to inspect your office. Sometimes you'll need to give a statement to them, but they'll need something signed by a deputy attorney general. And that information is just for the Consumer Affairs investigation. If they show up with state or local police or a federal official, those people will typically need a warrant. They'll need a warrant to search for very specific things. You have different rights. Obviously, you have your Fourth Amendment rights in that case, but they'll treat it much differently. So just be cognizant of who's showing up there, because you don't want to say something to an investigator who you have a duty to cooperate with to a police officer when you have the right to remain silent, and have them essentially leverage the expanded rights that the Attorney General has to investigate these types of cases with all of your constitutional protections you'd have in a criminal investigation. So, as I said before, does the investigator have a signed subpoena? If they don't have assigned anything, you don't have to just let them into your office. They don't have independent rights to search for any of this stuff. They need to be authorized by the Attorney General or one of the Attorney General's designees, which would be the Deputy Attorney General, who's in charge of the investigation. So if they just show up and say, "Hey, I'm Consumer Affairs, I need all of this stuff," you don't have to let them just take it. They need to have a subpoena. Be polite, but do not speak with the investigator. This sounds counterintuitive, but essentially say hello, ask who they are, ask for, the signed subpoena if they have it, ask to see their badge, but they'll typically show you that. You can make polite talk with them, show them where they need to go to find the things that they're trying to find. That way they're not just rummaging around your office and seeing things they wouldn't have otherwise seen, if that could be an issue. But don't give them anything that is of substance. If they come in and they say, "Where are the records for patient AB?" You can say, my patient records are in my EMR on this computer, and show them that patient record. But don't start telling them about why you were seeing patient AB, any of your medical decision making. Don't start to, if they say, "Well, I'm looking to see your medications," don't say to them, "Oh, well, I have some expired medications here. Please don't look at those," or something like that. The only things you should be saying to the investigators are, "Hello, can I help you? Can I see the subpoena? This is right here is where the item that you're looking for is." That's really all you should be having in terms of discussion, and also don't impede or prevent the investigators, because this would obviously be a violation of your duty to cooperate. And if you actually attempt to impede the investigators, the board will likely move to take your license in some limited fashion or in some total fashion. And if they're with police, then that can lead to obviously criminal charges as well. And then also importantly, and many people don't do this because these visits are often unannounced and their adrenaline starts running and they're not really thinking straight. But if you are ever investigated by somebody from the Enforcement Bureau, keep a record of everything that they look for. Keep what patient records were they looking for? What specifically on the patient records were they looking at? What part of your office were they looking at if they were inspecting your office? Did they try to speak to any of your staff members or any of your licensed staff? And the distinction is important because if they're only trying to speak to one licensed staff and they have a subpoena for that licensed staff, they may be investigating that person rather than you. If they try talking to only unlicensed staff or just trying to talk to the front desk people or something like that, they're probably conducting an investigation of your practice. But also, what are they saying to those staff members? What are the staff members saying to them? This will give important insights later on when you need to continue the investigation.
Yeah, my apologies. My
computer crashed at an opportune moment. But somebody asked, what if I already responded to the board on my own? What would I be able to, should I still get counsel involved? Does it look bad? Many times we represent clients after they have sent in a board response, but before they actually get to the hearing. Or maybe they just they went to the hearing on themselves and they got a consent order proposed for them. It's perfectly fine to get us involved at that point in time, because what we would do then is we would just go through the normal processes where we would negotiate on your behalf. If you didn't go to a PEC, but you did a board response and they wanted to talk to you about it, we would walk through with you where they might have found some issues with your board response. We would discuss with you in detail exactly what you would want to do on your own or with us. Most of the times, if you started on your own, we would take over. There may be a time when you may want to handle it yourself and we'd sort of coach you on the side, but for the most part, particularly if you get to the point where you are going to be presented with a formal consent order, that's when we want to get involved. It doesn't matter that what happened was, that you said something that you can't take back or anything like that. The most important thing that we want is to protect your interest. Make sure that you continue to practice without having any issues. So how do you minimize public discipline? Going back to a presentation, basically what they want to make sure is that your practice is being performed within the recognized standard of care. What that means is, if you're a pediatrician, are you doing things that a pediatrician would do, or are you giving Botox out? These are things that will get you before the Board of Medical Examiners and private insurance and public insurance auditors. If they see that you're providing services that typically someone in your area of specialty does not provide, then that's when you might be getting in trouble. Other issues are, keeping complete and medically appropriate records of all patient interactions. Sometimes we've seen issues where the board will discipline providers because they didn't keep sufficiently good records for every single patient interaction. They might be missing date of services. Things might be written in different color ink, so they might start to question the validity or appropriateness of something. And then, obviously, when your matter deals specifically with the prescription monitoring program, what deals with prescribing, they're going to look at your prescription monitoring program use. Are you using the PMP every time you prescribe? If you're prescribing opioids, are you doing routine drug testing? Are you doing random drug testing? Does everyone have a pain contract? When you get to the PMP, there's a lot of issues that pop up. And I know Alan's been dealing with that a lot lately because there's a renewed fervor by the Board of Medical Examiners here in New Jersey and in other states on opioids and prescribing.
And really, with the PMP, we've talked to a lot of doctors who follow all the regulations. They check it when they're supposed to. They do all of that, but they don't keep a record in the patient chart of the PMP when they checked it. They don't print it out. Sometimes their EMR makes a note of it. Sometimes it doesn't, but it's not something that's part of the patient record. While this isn't fatal, this is something that the board wants to see when they're investigating, typically prescribing cases, when they're investigating a doctor's prescribing opioids, just prescribing benzodiazepines. More often now, when they're prescribing stimulants, they want to see that the physicians are checking the PMP, they're printing out the readout from that day and putting into the patient chart as part of the record. So if you don't currently do that, I would just start making a habit of doing it. It's not something that would ever be fatal, but it is something that raises questions, especially when the doctor is, as a couple of these bullet points say, when you're practicing outside of your specialty, when you're practicing, if you're a primary care doctor and you have a couple of pain management patients, the board wants to see that you're following the rules to the letter. And if you're not printing out the PMP, if you don't have a pain contract, if you're not doing enough urine drug screens, these things will add up and the board will really start to have a lot of questions about what you're doing. So it's just an easy way to allay some of those questions.
Yeah, the next 2 points also kind of go hand in hand and are very related to one another. Minimizing the practice outside of your specialty and referring difficult or specialized cases to the appropriate specialist. The board has come down pretty hard on providers that they thought were maybe dabbling or trying to do two different things at once. For instance, they might be doing a regular OBGYN practice, but then starting a completely separate, biologics practice, and it's right next door. So it confuses the public. What they want to make sure is that one, you're not doing anything you're not qualified to do, and two, you're not potentially misleading the public, thinking that they're coming to you for one thing, and then you're treating them under another specialty. The last point here, and we've seen this a few times the last few years. We hadn't seen it before, but the board has started to crack down a little more when they feel that advertising at your websites are not truthful, or in applications to hospitals where there's an inaccuracy or a misstatement or something that looks to be dishonest or disingenuous. That's one area where I know Alan's had quite a bit of board work where in the past it was rarely brought up as an issue.
So I've actually seen this more on the prosecutorial side than I have on the defense side of people either purposefully or mistakenly misrepresenting or not being fully truthful in how they're advertising their credentials or their training or their experience or something like that. It's one thing that I can tell you, having seen how the board reacts to this both publicly and privately. Don't do this. They get personally offended when physicians say they have board specialty or they're board certified in certain specialties when they're not. When they say they're board certified in a specialty that doesn't have board certification. If you say you have a subspecialty when you only are board certified in the specialty, whatever combination you can think of that may seem like it's innocuous enough, or that maybe you're saying, you're not board certified, but something that kind of hints at you're board certified, but you're not saying it, and you're trying to get cute. The board takes those very seriously, and if you ever have a disciplinary investigation where you have to turn in your resume and something like that is on there, they will come down on you like a ton of bricks for that. That is something that they treat way more seriously than you would expect them to, and they have no patience for it, more so than almost anything I've ever seen. It's a little surprising. So make sure you're always being truthful in the way that you're advertising yourself and your experience. Okay, so just give me 1 second. In order to show cause, this is probably the second most severe step that a board will take that involves a hearing for you. The first most is an administrative complaint, although these two things really go hand in hand. So in order to show cause is essentially a letter that's ordering you to show cause to the board as to why your license to practice medicine should not be temporarily suspended. These are typically sent to a physician when there are significant enough allegations that the conduct palpably demonstrates a clear and imminent danger to the public health, safety, and welfare. And the language they use is very important, and we'll get to that in a second. But the way that these work is it's more similar to an indictment than it is a civil complaint, but even so, it's even more similar to kind of an injunction. The board has allegations. They don't have a complaint drafted. You're not going to appear before a judge. There's not going to necessarily be a lot of evidence. There'll be some evidence, there'll be some testimony, but it'll typically be just yours and maybe some of the evidence that the board has gathered. And you would need to appear before the board, preferably represented by counsel, because these will involve some legal and factual arguments. And you'll need to defend your license and explain why the conduct that they're alleging is either the allegations are not true, or conversely, why they don't require that your license be temporarily suspended. And you'll see that the temporary we have on the slide is in quotes, because temporary just means that at some point in the future, an indeterminate amount of time that's never explained, you can get your license back, depending on why it is that it's temporarily suspended. There may or may not be an endpoint, but it's never temporary, and as in like on a few days. It's usually months or more typically years. So what the board needs to do in order to show cause is to show that the conduct alleged conduct palpably demonstrates a clear and imminent danger to the public health, safety, and welfare. But it's important to focus on clear and imminent danger. The board is only going to use this tool if the conduct is recent, if the conduct has just been discovered, if it's something where they can show that if you are not taken out of practice right now, you can cause harm to your patients. That's the only time that they're supposed to use it. It doesn't mean that that's the only time that they do use it, and it will 100% of the time get tossed if too much time has passed and the cases become stale. So this is typically something that is used against doctors who are practicing in unsafe conditions. The one example I can think of off the top of my head was there was a doctor who was performing. It wasn't colonoscopies, but it was something similar to colonoscopies, and there was a tube involved, and he was not washing it between patients. It was very disgusting. It's very dangerous. The attorney general brought a complaint asking that the board temporarily suspend his license, and they took action immediately, because if he was allowed to continue to practice, he would have continued to engage in this conduct, and he would have caused danger to the public health, safety, and welfare. What they will not do is they will not take your license and in order to show cause if they're investigating your prescribing of medication from 5 years ago and determine that, well, the morphine equivalency is a little off and we need to, this might be a problem based on the CDC or whatever. That's not the way that they'll proceed in a case like that. So once an order to show cause, an order has been put into the record, if your license is taken, or even if it isn't, the next step would be for the board to file an administrative complaint against you, and that essentially follows a similar course to any other trial. It would go before an administrative law judge. There will be some motion practice. There will be discovery. There will be experts involved. There will be a final determination by the administrative law judge, which then goes to the board, where the board needs to accept all the factual findings, but does not need to accept the recommendation. So the administrative law judge can come to the conclusion that, these facts mean that you don't need to lose your license. The board can review it and find that actually these facts do mean that you need to lose your license. But really the big takeaway here is, with an order to show cause, is that of all of the types of communications you can get from the board, if you receive an order to show cause, you need an attorney. You just need an attorney for something like this, because the stakes are too high to show up on your own, and the board is simply not going to cut anybody who appears for an order to show cause on their own any kinds of breaks that they may in a similar type of circumstance.
Privilege is the most important thing that you have going for you during a board investigation. Unless the board has you enter into a consent order, or they file a formal complaint against you, or there's an order to show cause that they find against you, everything is going to be privileged. If they send you a letter with, can be very nasty fact patterns, can be just lascivious allegations, that's fine. Doesn't matter. It's all privileged. What we do is we help you craft a response. If we can get the board to agree to walk away from the case, to close it, which we do with most of our cases, what ends up happening is that they walk away from the case, they close it, and they keep it in their confidential files. The board's confidentiality is some of the strictest in the nation. You cannot request it through a Freedom of Information Act. You cannot request it through a subpoena. Even if you're suing that doctor, it doesn't matter. They have an incredible amount of immunity. So their privilege is some of the strongest we've seen in the country. Consent orders, those are public. That's why it's public discipline. And back in the old days, 10 years ago, you could enter into a private letter agreement, which was sort of like a consent order, but private. Those have gone, the way of the dodo bird. However, there are certain things that you can do where you can be proactive with the board, maybe enter into something like the physician advocacy program if the issue has to do with any potential substance abuse, or a disruptive physician allegation where they're saying that maybe you're being unruly at work. There are ways that you can still keep that privilege, essentially agree to some sort of discipline or monitoring, and keep everything privileged, so that when they get hopefully a favorable report from the PAP or whatever other course of action you may agree to with your attorney, when that gets resolved, the board closes their investigation and keeps everything private. So it's important to understand, don't talk to anybody about it. It's not something to vent to people about, because the only one who can waive this privilege is you. Keep it privileged. People don't have to know. If this gets closed, you really don't even have to put it on applications where they ask you if you've been the subject of a board complaint, because it's privileged and you weren't disciplined. So I know that gets into a little bit of what we're going to talk about next time as well. So thank you to everybody for joining us today.
Guillermo, there is actually a question.
Sure.
Says, with the PMP, isn't there an issue with delegation, not having the appropriate personnel querying the PMP?
So with the PMP, obviously, it is very regulated. And one of the things that they look at is, yes, who is looking at the PMP data. One of the more famous cases here in New Jersey was not too long ago, after Whitney Houston passed away of a drug overdose. There was an office manager who wanted to find out what drugs did she overdose from? What was she taking? So they ran her PMP. That was inappropriate. There are ways, it's my understanding, that you can delegate, but again, it has to be, there's certain procedures you have to follow. I know Alan has worked with some of our clients through those, and we can obviously touch base offline about that, because yes, there are ways around that.
Says, what if I already responded to the board on my own or attended a hearing unrepresented? Should I still get representation, or would that cause further issues?
Yep, we answered that question before, and yes, get an attorney involved as soon as you can, even if it's after appearing, because there's still things you can do to avoid public discipline or to at least lessen it. Even the terms of a consent order can be negotiated so that the factual pattern that they're going to write in that consent order can be tapered down, so that when someone's reading it, when it gets published to the National Practitioner Data Bank, it doesn't look as bad, it doesn't read as bad. So a lot of what we do a lot of times also is, we kind of play wordsmith, and we try to make it sound as innocuous as possible. So there's never too late of a time to get us involved, unless you've already signed the consent order. At that point, if you've already agreed to the discipline, there's not much we could do. But everything leading up to you being disciplined or signing a consent order, that's something we can definitely help you with.
And also, it's important to know it's not going to change the board's impression of you or your case if you get legal counsel involved. They're used to dealing with legal counsel. It's not something that they look down on. It's not something that they look up on. It's really neutral to them. In some cases, depending on the case, they may prefer to work with counsel. In some cases, they may not. But it's not going to change their impression of you or put you at a disadvantage if you show up for a PEC unrepresented and then get representation afterwards. The only disadvantage would be if there was an issue that happened at the PEC that would have been remediated by counsel.
Okay, well, thanks everyone for joining us again today. And as always, if you have any questions, please don't hesitate to reach out to us. You have our contact information, and we wish you have a great rest of the day and weekend. Thank you so much, everyone.
Thank you, everyone.